Mr. Kawai?
Morning. May it please the Court, my name is Paul Kawai. I represent the Cambridge Board of Zoning Appeal, the city defendant appellees in this case. Now, the fundamental issue here is whether a property owner who has validly obtained a building permit and is building a structure on his property is required to be named and served with a complaint to revoke said building permit in an action filed in Superior Court pursuant to Section 48, Chapter 48, Section 17, which I'll call Section 17 from here on out. Now, the appeals court answered that question in the negative, and this is a very important issue because, first of all, the appeals court decision directly contradicts a previous Supreme Judicial Court case. Second, it contradicts the legislative intent behind Section 17. And third, it results in the anomalous and potentially wasteful situation of a property owner who has built a structure without having been named as a party defendant and therefore served with a complaint, and putting him in danger of having to rip down the structure when all that needed to be done was that the plaintiff needed to hire a constable to serve the party whose rights are being litigated in this case, the owner of the property at issue.
Mr. Kwai, the address, there's no dispute, is there, that the person, Mr. Fifield, if I'm
Right.
pronouncing that right, sent certified mail, a copy of the complaint, to Mr. Azam, correct?
Well, he did send certified mail to 226 Hurley Street.
Where does that address come from? Because I couldn't tell from the record. Was that the Board of Zoning Appeals address that they had?
226 Hurley Street? Mm-hmm. Actually, the Board of Zoning Appeal sent its notice of the hearing to 1979 Mass Ave, which was the address of the property at issue, where the construction was happening. But I do believe Mr. Azam did reside at 226 Hurley Street, but I'm not sure if he was residing there at the time.
Was it his last known residential address?
I'm not sure where Mr. Bracken received that 226 Hurley Street, or what information or evidence he had.
Assuming it was his last known address, what's wrong with that?
The certified mail was returned. He tried. Section 17 allows service by certified mail.
Right.
But
doesn't it say that it needs to be sent by certified mail?
Right, but the reason the legislature put in that the party defendants have to be served by certified mail or by a constable, certified mail means delivery.
Well, if it uses the word send, why does that mean delivery?
Well, the legislature just could have allowed regular mail rather than certified mail. Certified mail means the complaint was returned.
What the certified mail will do is, I think the post office, as I recall, certifies that they have attempted to make delivery.
Right.
Correct? Mail that is not certified, sometimes it doesn't, there's not even an attempt to make delivery.
Well, I think what happens with certified mail is that a little slip of paper goes into the person's mailbox. And you're supposed to, the person living there is supposed to pick up the slip of paper and either sign for it or go to the post office and pick up the mail and sign for it.
Let me ask the question differently. Where the statute says you have to send by certified mail, are there any cases where we have said that service is not complete on sending by certified mail? You actually have to get a return receipt.
Not that I know of, Your Honor, but there's no other reason to require certified mail. And in a case where somebody's building a structure on his property and the complaint is returned with affirmative proof that there was no service, the property owner never...
It may be that somebody's trying to evade service.
I
mean, I'm not suggesting that's in this record, for example, but the post office will say, I put this through the mailbox.
Right.
Right? Now, somebody may not want to go and collect it, but we know that it was put through the mailbox.
That is possible, right, and that is true. But if the property owner has moved, or someone else is residing there, or they have the wrong address, and some
then in
other
those
instance.
cases-
But that can always happen. I mean, even by a constable, if you can leave it at the last and usual address, if they've moved, they're not going to get it, and we still consider that to be good service. I mean, isn't the person who is serving entitled to rely on what the statute says? And if it says send, and he sends?
Right, but implied with the certified mail is that it actually be delivered. In this case, there's evidence.
But the legislature can write a statute, and it has written statutes that says something doesn't happen until the intended recipient has received. You have to have proof of notice of receipt.
Right. The legislature did say send certified mail, but with the certified mail it implies delivery, and this decision by the Supreme Judicial Court would result in an anomalous and a potentially wasteful situation if parties were permitted to merely send a complaint by certified mail, which is then returned, knowing that the property owner is continuing to build on the property and continue with the litigation, litigating that property owner's property interests, knowing that the complaint was returned.
Did it refresh my memory? Was it returned unclaimed, or was it returned left no forwarding address?
Returned unclaimed.
Well, it was delivered.
That's
The
not
notice
in-
was delivered to the mailbox.
Where-
The
where in
notice-
Mr. Quai, where in the record is it show that it was actually returned as opposed to a notice saying it wasn't picked up and it may be returned? In other words, I think the record indicates simply that what Mr. Fifield got was, I'm not sure I have it here, but was something that back saying it hasn't been picked up. If they don't come, it will be returned. But I didn't see any evidence that it had actually been returned. And the other part of that is somebody, and maybe it was from the Board of Zoning Appeals, actually sent it by regular mail as well, didn't they?
It was an attorney in this case, but we don't know if somebody else was living there. We've never heard during the litigation in Superior Court in this case. We never heard from the property owner. Somebody did send by regular mail, which was not returned. We'll admit that, but in this case, I don't think it's been disputed that the complaint was returned because the notice was not picked up. The mail was returned to counsel for the plaintiff.
Did the person have a lawyer?
Yes.
The plaintiff?
Yeah. The
Mr.
landowner?
Azam, yes, he did. Didn't he?
Did any-
I believe Mr. Ozam did have a lawyer in the Zoning Board of Appeal hearing
He participated.
below. He might, yeah.
Does the record indicate that he was notified, or that lawyer was notified?
No, the record doesn't indicate that. And I'm not sure if he continued to be the lawyer after he prevailed in the Zoning Board of Appeal case. We're not sure if there's no evidence on the record.
Is this the same address? Was the letter sent to the same address that appears on the application for the permit?
I'm not sure.
Well, I'm just going from what you said earlier. The answer probably would be no, because the building that was being built had a different address than where Mr. Azam lived.
Right, and
But doesn't the applicant
The
have
applicant
to
has to put an
address on the application?
You can have
Right.
a vacant lot. So, and I apply for whatever it is, and I say, this is how you contact me. And sometimes that's the name of my attorney,
right.
and sometimes it's my address.
I do know notice of the zoning board hearing was sent to the property, the 1979 Massachusetts Avenue. It wasn't a vacant lot at the time. I guess it was a funeral home that was renovated into an apartment complex.
Okay.
So I do know that, and the appeals court did not rule on the return certified, whether return certified mail constitutes valid service. It ruled on another issue, but if the court is inclined to look at that issue, I do believe that if this court rules that return certified mail can constitute good service, property owners are going to be placed in danger of having their buildings ripped down if they're not living at the property that they were living at from before, or from however the plaintiff's counsel got the address of the property owner. Now, the plaintiff's
If
counsel...
somebody's a pro se litigant and they file something in a court and they have to put down their address, if they move without telling the court sends the notice of whatever the decision is to the address that was last given to us. Why is that any different?
Because this is a complaint filed in Superior Court. for the revocation of a validly issued building permit. The building permit was issued by the building commissioner, and it withstood an appeal before the zoning board of appeal. The property owner is completely entitled to start building at that point. He can immediately act on his building permit and build on his property.
Well, you say they should have used a constable. If the constable went to their last known address, how would that be any different than sending certified mail?
Because you would know that at least the constable left the complaint at the address and the complaint was there, rather than having evidence that the complaint was returned to the counsel for the plaintiff, that the certified mail failed.
Well, then the language on the return is very critical, isn't it?
Right. But the fact that they required certified rather than regular mail shows that the legislature intended that the complaint be received.
But that's not what the statute says. The statute says to avoid delay in the proceedings instead of the usual service of process. In other words, the usual service of process is by a sheriff or a constable.
Right.
But the reason is to avoid delay in the proceedings. The plaintiff shall, within 14 days, send written notice thereof by delivery or certified mail to all defendants.
Right, but
By delivery, I don't know what by delivery means, but it probably means that I can get a delivery service to drop it off.
Right, and either way, delivery or certified mail implies that the complaint actually has to be delivered.
Well,
rather
no,
than
because a delivery service, I can assure you it happens every day here. They deliver, and it's left at the Supreme Judicial Court, and if it's at 10 o'clock at night, as sometimes happens, maybe it's left out at the front door.
Right.
Nobody's signing for it.
Yes, but in this case, we know that the complaint was returned, and therefore we have affirmative evidence that possibly that he wasn't living there.
Okay.
You say it's returned, but all that's in the record is a notice saying we attempted to deliver, and a notice was left. It can be redelivered or picked up at the post office. If the item is unclaimed, it will be returned to the sender. But there's no evidence it was returned to the sender.
Oh, I think it's undisputed that the complaint was never picked up, and therefore, because it says if it's not picked up, I believe the language it says in there, you can infer that it was returned.
Thank you,
Because it says
Thank you, Mr. Kawai. Mr. Blacken?
Isn't this case pretty simple?
I think
Your
it is
client
very
is a necessary party to the proceedings, so he's got to get notice. The
Nope.
statute says send by certified mail. That's what happened. Apparently wasn't claimed, but it complied with the statute, and that's the end of the case.
I would agree, Your Honor. And I would also say that this case is completely, the case here has already been decided in three cases: the Zuckerman case, the Pierce case, and the Capuccio case. In the Zuckerman case, the court focused on the language that Chief Justice Marshall did, which is send written notice by delivery or certified mail, and distinguish that from the prior provision that says that with respect to giving notice to the city clerk, the notice must be given so as to be received within the 20-day period. So, for the clerk, the notice which was given in this case was given within the 20-day period with a copy of the complaint, and it was received on the day that it was given. As far as sending, in the Zuckerman case, the court was addressing Section 15, which is mailing notice to interested parties, and the court said mailing means sending of the notice, not receipt. And in the Zuckerman case, this court was following the prior decision in Survey and Research, which provided...
Do we know in the record how the address was how your client is Mr. Fifield, right?
Yes.
How he got the address?
The address
To
was the
send the
address
certified mail
that
to?
had been used throughout the proceedings. Whenever I sent letters to the building inspector, I sent copies to Mr. Azam at this address. They had never been returned.
And he participated in the hearing.
Is what?
And he participated in the
Well,
hearings.
under the Cappuccio case, it holds that if a party participates in the hearing, then he has constructive notice. And as the decision of the board says, Mr. Azam was there. He was there with his lawyer throughout the hearing. There is no indication that the board didn't give him notice of its decision. So he had notice of the decision. He knew that there were 20 days in which to appeal. He could have easily gone to the town city clerk at the end of the 20-day period and says, hey, has the appeal been filed? He would have found that it had. Moreover, he would have found that he had been named as a defendant. Now, the appeals court specifically found that notice had been given to 22 Hurley Street, and I quote, where Azam had received and continued to receive his mail. So
Is that in the record?
Yeah, where in the record
Where
is
the
that,
record is-
though?
I'm reading
I know
from
it's in
the appeals court. This
right.
is attachment.
What did
No,
the
no, no,
appeals
What do
court
they
rely
base that on?
Yeah, what's the evidence?
On which
Well,
the
the
appeals
evidence
court...
relied on was the fact that the city itself had sent its pleadings, all of the pleadings in the case, to the 2226 Hurley Street
But
address.
is there anything in this record that indicates that is where the city sent all its pleadings? Apart from the appeals court decision?
There's the letter. There's the letter from the city solicitor. It is in the appendix. I believe it's in the appendix. Actual
it's there.
notice. She not only sent the pleadings, she sent all appendix 148. She sent the letter to 226 Hurley Street. She said, I'm sending you all the pleadings, plus all the motions that have been filed since then. And there is, and as the lower court found, there's no indication that that was returned to the city.
Do we have a copy of the application for a building permit in there, in the record?
That is not in the record. But I don't believe he'd used that address. I think he used the address of the property which is on Mass
There
Avenue.
have to be some record basis to show that Mr. Azam's address was where the certified mail was in fact sent, correct? Because, and I think you've got that here, because it's conceivable that somebody was trying to pull a fast one, that was not the case
Well,
here, could
as I
send
say,
it to
during
some
the-
address that doesn't exist with that person
When
comes
we were
back
trying
unclaimed.
to verify where to send the appeal by certified mail, we went to the internet. We found Google, Yahoo, I don't know how many. They all gave the address 225 Hurley Street. Yesterday I said to my secretary, check those to see if he still lives there. She came up with 226 Hurley Street. I don't think there's ever been a dispute that the man's residence is 226 Hurley Street. That's what the plaintiffs relied on. That's what the city relied on. The city sent all the papers to that address. They didn't come back. None of my mail during the administrative proceedings came back. And but in addition, there's the constructive, the cases, the Cappuccio case, the Pierce case, hold that once the proper notice and has been made to the city clerk, that is notice to all interested parties, which this court found in the Cappuccio case, the owner is an interested party. Somehow the city was arguing that only interested parties is the public and is not the owner. And then in the Cappuccio case, the court went on to say that if you participate, as the owner did in the hearings, then you are on constructive notice, and then you have an obligation to continue to make inquiries in the clerk's office to determine whether the appeal has been made. So certainly, even if Mr. Azam never went back to bed at night and picked up his mail, still he had constructive notice and he had subsequently actual notice of the proceedings. Now, he did go ahead and construct because he wasn't under any injunction against construction, and even though he had constructive and actual notice, he was free to continue to construct, which he did. Now,
But if you win this case, he constructed at his own peril.
Well, he did, but I mean, he proceeded from the very beginning at his own peril, because clearly he had notice through the administrative
Well, that's
proceedings.
what I'm
We were
saying.
challenging his right to build because it didn't comply with the zoning
How could he
requirements.
build without the permit?
We had a building permit. We were
His
challenging
action
the
is
building.
to revoke it.
We brought, that is the plaintiffs, we made a request to the building inspector to revoke it. The building inspector refused to revoke it because he said he didn't have the power to revoke a building permit for violations of zoning ordinances. He only had the power if there was a showing of fraud or misrepresentation in the application, which he didn't find.
So then you went to the ZBA.
Then we went to the BZA, and lo and behold, the BZA agreed. They said, well, we don't find any fraud or misrepresentation in the application, therefore we uphold the building inspector. Then we went to Superior Court. Then we were all prepared to argue before Judge Herman Smith 2 years ago on cross motions for summary judgment. And that got derailed by a motion, which we also claimed was not a timely motion, to dismiss for failure to serve a necessary party, because they didn't bring that motion with their initial 12B motion, which under 12BG says when you bring your first motion under 12B, you've got to bring all other motions, including this motion that resulted in the dismissal of the case. So for the last 2 years, we have been focused on this issue. Certified mail, constructive notice, actual notice, and here we are.
Thank you, Mr. Blacken.